Good day, Crime Talk aficionados. As you can tell, we're not in the Crime Talk studios. We are on the road today for work. But we only have one story for you today. And it's a story that's, frankly, I'm not sure who to be upset with, the court or the YouTuber that basically made it so we won't be able to see any of the live streaming in court for the Barry Morphew case, at least for now.
All right, lawyer.
So let's just go ahead and read it because, well, frankly, it kind of sums it all up. This is in the case of Barry Morphew, case 25 CR 128, order granting defendant's unopposed motion to cease unmonitored live stream of court proceedings. Here we go, ladies and gentlemen. Hold on. And this is why I've told people this. When you stream something from Colorado, you can't. You have to get court permission to do so. And if you don't, well, you can basically be held in contempt. So here it goes. This matter comes before the court on the defendant's unopposed motion to cease unmonitored live stream of the court proceedings, which means the prosecution doesn't object. They're on board with it. This was filed back on September 19th, and the defendant's motion number 9 attempts to address violations of the Colorado statute as well as the Chief Judge Directive 2302 concerning the recording of live streamed criminal proceedings. For both reasons, motion 9 is granted. Both this case and the prior one against Barry Morphew have garnered unbelievable amounts of local, state, national, and international attention. And if you enter Mr. Morphew's name into any search engine, many thousands of results return. This is perhaps not surprising considering the explosion of interest in true crime genre within the developments of podcasts and streaming television in the last decade. There are more than 20,000 true crime podcasts in existence and available for free podcast services like Apple Podcasts and Spotify. Several podcasts have already covered this case against Mr. Morphew in some capacity, but this level of interest has also increased the level of difficulty. A court such as mine has in protecting the right to a fair trial and the safety of those involved in these sorts of cases. There have been 2 court dates in this matter since the grand jury returned an indictment against Mr. Morphew on June 18th of 2025. Both have been available to the public via the state's live streaming service. Following the September 2, 2025 status conference, it came to my attention that an individual with a YouTube channel called JLR Investigates posted a recording of the status conference, including the admonition that there shall be no recording made. JLR Investigates' unlawful recording included comments from some of the 17,000 plus people who viewed the unlawful recording. And then we have a footnote here. It says both the content of the screenshot of the unlawful recording and the commentary by viewers was redacted in the publicly available version of Motion 9 and will not be repeated here in the public available order to prevent further harm from this behavior. The unredacted version of the defendant's motion will remain available for appellate court review. Let's come back. Some of the commentary, including from JLR, takes issue with the constitutional requirement that the defendant is presumed innocent until proven otherwise, propounds several conspiracy theories concerning this case, and threatens violence against me, the judge, right? Attorneys for both sides, and others included several victims. But JLR Investigates is not the only YouTube channel that unlawfully recorded and then posted live stream hearings in this matter. Footnote number 2, the defendant's motion also discussed the conduct of other YouTube channels that similarly displayed unlawfully recorded live stream proceedings and channels that recorded others concerning behavior related to this case. I took these to be examples of the most egregious behavior that unfolded after the September 2, 2025 hearing. Not an exhaustive list. These individuals, including JLR Investigates, will hereafter be referred to as the offending observers. The names of these additional offending observers are being excluded to prevent further traffic to their channels, thus compounding the problem that they created. Defendants accused of criminal conduct are entitled to a public trial by both the United States and Colorado constitutions. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, specifically through the United States Constitution, Sixth Amendment, Colorado Constitution, Article 2, Section 16. In all criminal prosecutions, the accused shall have the right to a speedy public trial. The right to a public trial belongs largely to the accused. And she cites People v. Jones. That is so that the public may see the defendant is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and to the importance of their functions. She cites some case law. Contrary to the purpose for which the offending observers have used it, the right to a public trial exists for the purpose of preserving an accused's right to the presumption of innocence and in ensuring legal professionals provide the best, most competent services possible to the community we serve. The right to public trial is not without its parameters or limitations, and it can be waived. Even constitutional rights can be waived, although I should indulge every reasonable presumption against such a waiver. I do not find that in making a request to disallow live streaming of the proceedings, the defendant is waiving his right to a public trial generally, but he is voluntarily to have a limitation placed on that right. Public trials do not only belong to the accused. Public access to criminal trials permits the public to participate in and serve as a check upon the judicial process, an essential component in our structure of government. The benefit of the public of access to criminal proceedings include allowing the public to see that the accused is fairly dealt with, ensuring that judges and prosecutors discharge their duties responsibly, encouraging witnesses to come forward, discouraging perjury, and allowing victims and the community to know that the offenders are being brought to justice. These laudable purposes cease to exist, however, when some members of the public exploit access to criminal proceedings for purposes anti-ethical to these goals. Not every restriction on the public's access to criminal matters may result in constitutional violations. There is a 4-part test announced in Waller, which is a case to determine if a courtroom closure complies with the Sixth Amendment. As the party seeking to close the courtroom advanced an overriding interest that is likely to be prejudiced. Is the closure no broader than is necessary to protect that interest? Are there reasonable alternatives to closing the proceedings? And have I made a finding adequate to support the closure? The Sixth Amendment guarantees a right that trial is open to the public, meaning that the public has a reasonable opportunity to be physically present to observe the proceedings. Nothing in my ruling will prevent that opportunity. In contrast, I do not pause the unfettered live streaming of hearings in this case. At best, the unlawful recordings and the venomous commentary may affect both or either party's right to a fair trial by tainting a small jury pool, though the prevailing of factual inaccuracies in the court of public opinion. While the impact of outside commentary is not an uncommon concern in a high-profile case, what is concerning because of the behavior of the offending observers rises to a level of seriousness beyond that which something like a change of venue can resolve. At worst, the calls for and acts of violence against the parties and legal professionals will lead to someone being physically hurt. In 2023, the Colorado legislature mandated that criminal proceedings in open court be made available for remote viewing and listening in real time. There are several reasons for limiting that process that include the courtroom does not have sufficient technology capabilities. Members of the public have been excluded from the criminal proceedings by orders of the court. Technology, staffing, or internet issues limit or prevent remote observations. After a request by a party, witness or victim, or the court's own motion, the court makes findings on the record based upon the particular facts and circumstances of the case. There's a reasonable likelihood remote observations of live proceedings risk compromising the safety of any person, including the risk of physical and emotional safety, intimidation and harassment, and the defendant's right to a fair trial, including violations of a sequestration order or the victim's right to pursue the victim's rights. There is no less restrictive alternative that prevents the public's interest in remote observations while mitigating the identified risks and allowing remote audio-only observations while disabled video observations or turning off remote observations. The statute requires that the court ensure there is audio or visual recording without the permission of the court and gives examples of what reasonable steps must be taken in the same vein, and it cites to the statute. The Colorado Judicial Department has already taken these steps that it can several warnings that recording is prohibited. Additional measures are not possible in this situation, as explained below. The statute also allows the Supreme Court to prescribe rules, procedures implementing this particular statute, and the Supreme Court has done so via the Chief Directive 23-02, live streaming criminal trial court proceedings. The CJD provides a list of considerations that must be made before limiting live stream. Whether there's a reasonable likelihood that live streaming would interfere with the rights of the parties to a fair trial. Whether there's a reasonable likelihood that the live streaming would create an adverse consequence to a party, attorneys, victims, or witnesses. Whether there's a reasonable likelihood that live streaming would unduly detract from the solemnity, decorum, and dignity of the court. Whether any prior violations of this directive or other rules of the courts have occurred in this matter. The level of public interest in the case, consideration of the Victims' Rights Act, whereby the victim has the right to be present in person, by phone, virtually by audio or video, or similar technology for all critical stages of the criminal justice process, and considerations of the American with Disabilities Act, whereby deaf, hard of hearing, and deaf blind individuals may request communication access through services by completing the judicial ADA request. Furthermore, live streaming shall only occur when viewers conduct themselves in a manner consistent with the solemnity, decorum, and dignity of the courtroom. The CJD further confirms that there shall also be no recording of any live stream proceedings, but that nothing in the CJD modifies the process for expanded media coverage. The actions of the offending observers meets the criteria necessary to restrict live streaming in this case under both the state and the Chief Judge directive. First, the offending observers and some commenting on the unlawful recordings have advocated an outright threatened harm against me, referring to the judge, attorneys for both sides, the defendant, and most disturbingly, the victim of this matter. While these types of threats towards those involved in the justice system are unfortunate, no longer uncommon, individuals who either follow and or like-minded of the offending observers have taken steps further by doing things like doxing the former judge on this matter, sending threatening letters to the home work address attorneys involved in this case, and leaving a dead fox on the front porch of one of the attorneys' homes. That is beyond the pale of simple commentary on their work to hold them accountable or disagreements with the decisions of the course of this case. These are terrifying, unlawful attempts at intimidation and harassment and have no place in our justice system. Second, Alamosa County has a comparatively small jury pool. While I would never prevent general publicity of any case of interest to the community, that publicity will likely prevent at least some in our small jury pool from being fair and impartial jurors on this case. The actions of the offending observers threaten to exacerbate the problem by showing parts of the proceedings and its participants that the credential media, for good reason, are prevented from showing, and making statements purporting to have some sort of inside information that they would not never be provided to the jury because it's not real or an actual fact. Any less restrictive remedies would prove fruitless. The Colorado Judicial Department has posted in several places admonitions against precisely the type of behavior which has occurred, recording live streams. Those warnings were ignored and even included in the unlawfully reproduced material. Switching to an audio-only format would not prevent threats and harassments toward the parties of the victims, even if the audio is not reproduced. Descriptions of the individuals involved in this case and the threatening behavior toward them are unlikely to cease. The Colorado Judicial Department does not have the technology capable to monitor participants in live streaming, let alone the staff to check the various social media outlets to ensure no violations of admonitions against recordings have occurred. It would not be judicially economical to proceed with citations for contempt of court against all of the offending observers, even if the true identities of each could be ascertained, which is unlikely. And it would be unfair and perhaps unconstitutional to proceed with citations for contempt of court against only those individuals like JLR investigates who true identities can be known. Finally, noting in the order prevents the credential media from reporting on this case pursuant to the order preemptively granting requests for extended media coverage, which will be amended to accommodate credential media who previously used the live stream. Furthermore, the public is welcome to observe these proceedings in person. Therefore, the defendant's unopposed motion is granted. Nothing in this order changes the manner in which the victim, the defendant's family or staff, or representative attorneys may have access to the proceedings, credentialed media access, and reports on the proceedings as outlined in the amended order, preemptively granting requests for expanded media coverage. Members of the general public may attend these proceedings held in open courts and subject to the following conditions. Only so many people may be permitted to enter in the court safely, to fit into the public gallery, less accommodations for the victims, the defendant's family, and the row reserved for credentialed media. Members of the public will not be permitted to bring into the courtroom any cell phone, laptop, tablet, or any other electronic device capable of recording. Members of the public must comply with all verbal and written instructions given by the security of law enforcement, and any person, including the member of the public credentials, a member of the defendant's family, or member of the attorney staff, who record, photograph, or otherwise behave in contradictions of this order will be removed from the courtroom, will not be permitted to attend future proceedings, and may receive a citation for contempt of court. As this case continues, I may reinstate the ability to view certain proceedings via live streaming depending on the circumstances of this particular case. And that is signed by the judge, Amanda Hopkins. So let's dissect this real quick. All right. When you go on the live streaming for the state of Colorado, it clearly says you cannot record it. All right. We have not recorded it. I would love to live stream all of these proceedings. We've done that in many, many cases, but it's been authorized by the court. Frankly, this case should be authorized by the court. The only way that you make sure that there is not misinformation is that you let the facts from the court come out so that everybody can see what's taking place and what doesn't take place. Now, this goes out here to this JLR investigates. I've seen a couple of those videos. Seems like a decent guy. I think he got over his skis on this particular case. But he basically, let's face it, he's ruined it for everybody. And then all the people that would threaten people. We talked about that. We are free speech advocates, but you can't make threats to individuals. That's against the law. All right. And so these knuckleheads have now ruined it for everybody. At least if it was live stream, we could watch it and take view. Now the only people that can do it are credentialed media, right? The Denver Post, the ABC, NBC, CNNs. They can watch via WebEx, which is a separate than the live streaming, and they have to have their faces on, and it can't be recorded. And obviously, if they do, then they can face contempt cases here. So a couple of takeaways. One, as JLR investigates, and I'm nothing personally against the guy, but let's face it, he ruined it for everybody. All right. And all the people that threatened the attorneys, the defendants, and everybody else in this particular case, the judge. What a nut. Seriously, that goes completely against everything the American system is made for. And frankly, I wish the judge did have the resources and had the time and could go after all of the people that made threats to the participants in this case. Completely uncalled for. Unbelievable. The other thing the judge is worried about, because people go off on these conspiracy theories thinking they have some inside track. That's why we like to keep it with the facts, right? We stick to the facts. We stick to the analysis of what we know, and the facts may change and the analysis may change. That's called being intellectually honest. All right. But some of these people, and we saw that in the Brian Kohberger case, have no grasp in reality. There's still people that believe that Brian Kohberger was innocent. He gave up that presumption of innocence when he pled guilty. All right. Barry Morphew is entitled to that presumption of innocence. All right. You can read the affidavit. You go through it. These are the facts that we know. Public information. But to say that you have some other information, unless you're going to go turn that over to the police, just stop it. And not just because I'm an attorney, but there's a lot of people, they mean well, but they do more harm when they don't know what the hell they're talking about. All right. I got to go to work. Yeah, we're here in a restaurant, but this just upset me so much. One, this JLR, man, you messed it up for everybody. Two, it should be live streamed, and I would take issue with the court's order, respectfully, of course. I disagree with her because I think the way that you keep misinformation from coming in is that you actually show, and you should allow people to stream as much information as possible so that the true facts get there. And you can say, no, here's what took place in court, not some tin hat crazy conspiracy theory who has no concept of what takes place in the law, the procedure, or anything else like that. So that's all I got to say about that. Thanks for watching. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. And remember, the Constitution matters, as the court noted.